Lawyers of Reddit. What's the wildest loophole you've seen exploited in a courtroom that succeeded? Story 1. I racked up parking tickets in law school, only to find out that the district had changed but the signs were never removed. The street behind the school was in a different district, one with no time limit on parking. The neighbors didn't want students parking for hours on end, so they treated it as de facto timed parking. I defeated the tickets, but only after a contentious hearing where the hearing officer asked me why I thought it was okay to park wherever I wanted despite the signs. I said the signs don't matter if they're not legal, and he said enforcement officers go by the signs, not the map. I asked if I could just put up signs wherever I wanted to not have people park and they would enforce it. He didn't have an answer for that one. It really bothered me that the school made a big deal about getting a dispensation on parking time during exams because the exams were an hour longer than you could park. Comment 1. This happened to me in school, but I came out on my break as she was writing the ticket. The meter maid told me before I even said anything that she understood the classes ran longer than the meter time, but she still was going to write the ticket. It still makes me mad 30 years later. Comment 2. I got one because they ran my plate and I had a valid parking tag. The tag was in my cup holder, clearly legible, but since, yes, it wasn't hanging from the mirror or on the dashboard, then it wasn't properly displayed, still got a parking ticket. They should give everyone one mulligan a year or something. Comment 3. You might like this. My friend and I would always park on a certain street for college that had no meters, and 3 different times she got a parking ticket for an overdue meter. She told me she went to court each time to contest it, and on the 3rd time, the court actually called the same cop who had issued the ticket in. Comment 4. Well, this is just relayed from my friend. She told me the first time the cop dismissed the ticket, as well as the second. I guess she kept getting the same judge because she said the judge was upset on the 3rd time and just asked to get the cop's badge number so the judge could dress them down. Story 2. I got the physical evidence, a bag of substances, thrown out because the officer reached into my client's pocket before patting the outside first. Because that was the only evidence that my client committed a crime, the prosecutor was forced to dismiss the entire case. Comment 1. I had a case against me thrown out when body cameras were brand new, and a cop had filmed himself being adamant, absolutely adamant, about why they were searching my friend's car, which didn't actually have any legal backing, and then they wrote a different reason in their report, and the judge was all, oh no, though. The prosecutor had been yelling about putting me in prison for 10 years, all the while it was not my weapon, and legal anyway, not my substances, and trust me, that was a wild week. If we'd known those substances were there, I swear to God, we would have used them already, and I did have my own pants on that day. All's well that ends well. Cops didn't get fired for illegal searches, though, of course. Comment 2. My husband's uncle got caught with an ounce of cannabis. When it got to court, he was charged with possession of 14 grams of cannabis. Uncle loudly declared, "No, it was 28 grams, I just purchased it, I saw them weigh it." It got thrown out of court. Story 3. There really aren't loopholes like that where people dramatically win a case in court based on a word in a statute no one else read or whatever it is you're thinking of. Closest thing I can think of. I knew of a criminal defense attorney that had a slight foreign accent. When he had a lost cause of a case, in court he would sometimes play up the accent heavily, pretend to understand less English than he really did, generally play dumb, and so on. This was juxtaposed with one of the best prosecutor offices in the country, who were all very polished. His hope was that the jury might feel sorry for his client and acquit him even if they thought he was guilty because it felt like he never had a fair shot. It was a fine line to walk to do that and not upset the judge though. Comment 1. This guy was like, Citibank isn't real. I shouldn't have to pay my mortgage. He represented himself because every lawyer he spoke to was like, you're a moron. That's not how it works. Absolute loser of a case. He was 100% right. Citibank messed up when they deregistered in Australia. The court held they couldn't reincorporate just to sue this guy. Comment 2. I had a professor in college who was friends with a lawyer. I can't remember if he was defense or prosecution, but it doesn't matter. The lawyer was from the South and could switch accents between Southern and Midwestern. He used his Southern accent because people tend to underestimate people from the South. Story 4. I got in a no-injury car accident, gave the cops my insurance which had both my name and my dad's name. I'm a male with a name that is normally a female's name. The cop wrote the ticket to my dad because he assumed who I was by the names on the insurance. When I went to court to pay the fine, the judge told me I couldn't represent my dad. When I explained that he was living very far away from the accident and I was the driver, the judge said, "Well, you have no ticket, and your dad obviously wasn't the driver, so case dismissed." Comment 1. I heard of a similar case. From what I remember, this guy and his uncle had the same name and worked at the same company. A legal case was brought against the guy, but they served his uncle. At trial, the plaintiff was trying to get the guy to admit to something, and he's just like, "No, I did not do that." Lawyer. Is your name, uncle? Yes. Lawyer. And on date, did you do this? Uncle. No. Lawyer. Is this your name on this time card? Uncle. Yes. Lawyer. So you admit that you worked on this day? Uncle. No, if I recall correctly. The judge stopped it after a bit. Comment 2. My husband got a ticket for expired tags. Total oversight on us. We had recently moved across the state and got new jobs and just forgot. He went to pay the ticket and realized the ticket wasn't under his name or our car. Not really sure what the cops did, but the only correct info on the whole ticket was our address and the make and color of the car. The clerk at the courthouse said it can't be fixed. You have to show up for court and tell the judge to get it fixed. So my husband took a day off work, and after explaining the issue, the judge, super irritated, called it sloppy and incompetent and waived the ticket. Which was great, but taking the day off work actually cost more than the ticket. Comment 3. My dad and uncle are identical twins. In our state, your driver's license number is generated using a formula that includes your name, date of birth, and other basic info like that, which are identical for my dad and my uncle. Their first names share a first letter. As a result, they have identical driver's license numbers. The state anticipated this possibility, so all driver's license numbers end in a -0 by default, and if there are duplicate numbers, they will get a -1, -2, and so on. These are extremely rare, however. My dad has the -0 license, my uncle has the -1. Since police officers just assume it ends in -0, since 99.9% of the time it does, every traffic ticket my uncle has ever gotten ends up going to my dad. Since he can usually prove he was not operating the vehicle, my uncle has gotten out of a lot of tickets as a result. Comment 41. The cops only identified you by insurance card, not ID. That is not how that is done. Point 2. Even if you didn't have an ID, which would be pretty unusual for someone with valid proof of insurance, everyone on every call gets run through NCIC, which requires name, date of birth, and sex. Point 3. Even if we assume that this cop didn't do anything correctly, he issued a citation to a name only? Have you ever seen a citation? That's not how that works. A citation is a legal summons and requires name, date of birth, sex, and address at the very minimum. Comment 5. Me and my dad shared an address at the time. I was 16. And a county sheriff happened to be the first on the scene because he was a few cars behind me. The sheriff is the one that took my ID and insurance, and I guess ran my ID. He was headed home and was off duty but waited for local police to show up. Local police wrote the citation. So I don't know where the error occurred, but they got everything right on the citation except for the name. It was my date of birth but the wrong name. I am assuming it was from the insurance card because that was the only thing linked to my dad's name. I owned the car. Story 5. Still in law school, but I'm amazed at how few loopholes there are. I'm always on the lookout, but there's usually some catch-all, some provision, some exception, some countervailing doctrine that prevents it. The closest thing I've found to a clear loophole is that some items are exempted from the list of what can be seized to satisfy a judgment against you, but without specifying a maximum value. Like under New York's CPLR, even though exempt books can't exceed $500 in value, religious texts have no such limit, so theoretically, if you invested all your money in expensive rare Bibles, they couldn't be taken no matter what. Comment 1. The closest thing I've encountered to actual legal loopholes are jurisdictional issues where there is no one clear singular organization in charge, so nothing can be done about anything. It's a loophole in the sense that people can commit crimes and get away with them not because they aren't illegal but because there's no means of enforcing the law. To give an example, I've been told that this used to be the case a lot with jurisdictional issues around Native American reservations. It wasn't uncommon for the people on the reservation to know who had committed a crime, but Native American police couldn't do anything because the perpetrator was a white person who didn't live on the reservation, and as long as they never came back to the reservation, they couldn't be touched. Meanwhile, the regular state police had no jurisdiction over the crime because it happened on reservation land, and they can't prosecute crimes that happen there. Federal police also don't have any jurisdiction unless the crime committed is a federal crime. My understanding is a lot of these loopholes have been closed, but it created a vacuum that made Native Americans living on reservations easy targets for crime because these enforcement loopholes basically meant you could do whatever crimes you wanted on their land and face no punishment. Story 6 heard of at least one case where the defendant was charged with carrying a loaded firearm without a license, but the count had to be dismissed because it turns out the individual had loaded it with the wrong caliber bullet. The police lab tried repeatedly to get the gun to fire in the range using the defendant's bullets, but even they couldn't make it work. So technically, the firearm didn't count as loaded under the statute. It wasn't quite case dismissed, because there was a lesser charge that still applied to an unloaded firearm, but it was a much less severe charge. Not sure if that's a loophole, but it's one of the funnier and more harmless get-out-of-jail-free cards I've seen. Comment 1. The iconic photo of a lawyer with a rifle and his wife holding a pistol awkwardly was an interesting one. The pistol had been used as a prop during a court case, so it had been altered such that it couldn't fire. When the police seized it, they noticed that it had been rendered inoperable and fixed it. Altering the state of the pistol from an inoperable prop to a weapon didn't help their case. Comment 2. This is an interesting one. I know quite a few countries have worded it such that it doesn't matter if the weapon is fake, only that a reasonable person would believe it to be real. Makes it so using a replica weapon carries the same charge as if it were a real one. Story 7. I'm not a lawyer, but this was a fun one to watch. Someone received a speeding ticket on Main Street in Ann Arbor. He proved that 85% of drivers on that road drive faster than the speed limit and argued that the limit was improperly set under Michigan's anti-speed trap law. Judge agreed and ticket was thrown out. If everyone speeds, nobody does. Story 8. The wildest loopholes I've seen are really tame. The cops made mistakes. A truck driver was given a ticket for driving an overweight truck over a bridge, and the cop didn't weigh the truck. A guy was given a ticket for failure to yield at an intersection when he did a U-turn in the middle of a highway, causing an oncoming driver to rear-end him. Stupid stuff like that. Comment 1. I know a guy who got away with a driving under the influence charge because of fruits of a poisonous tree. They pulled him over for an illegal U-turn and then gave him a driving under the influence charge. The problem? It wasn't an illegal U-turn. The cops made it even worse though when they were caught on the dashcam saying, one cop talking to another, Cop 1. I don't know what to do, he passed the field sobriety test. Cop 2. Arrest him anyway. Comment 2. I'm a public defender, and I got a driving under the influence charge suppressed because the cop pulled my client over for making a left turn out of a business driveway across a double yellow line. Which, it turns out, is legal. It was so satisfying. The district attorney ended their questioning of the cop. The judge looked at me and asked if I had any questions on cross-examination. Nope. Judge rolled his eyes as if I just wasted his time and asked for argument. I pulled out 3 copies of the vehicle code statute, one for the judge, district attorney, and myself. It clearly permits one to turn as my client did. The district attorney tried to lie about what the cop actually said. I'm like, nope. It's clear as day on the record. Motion granted. Case dismissed. Comment 3. I don't know what state you're in, but if that type of turn wasn't legal here, I literally couldn't ever leave the grocery store. Or the church. Or the nearest pizza place. It's wild to me that a cop would think that was illegal to the point of pulling someone over. Comment 4. This is why we don't have field sobriety tests in Australia. We have laws saying how much alcohol you're allowed to have in your breath, and the cops carry a handheld device that measures it. If you get done for too high, they take you to the station and do it again with a more official machine. That takes time, which helps your blood alcohol level go lower, so if you're only just over on the roadside test, there's a good chance it'll be below by the time you get the official reading done. Story 9. I am not a lawyer, but two cases come to mind. For a period of time in my state, if you got a speeding ticket, you could have a hearing and request the radar technician to testify that the equipment had been calibrated correctly. Given that there were only 2 technicians qualified in the state, they basically never showed up, and the ticket would get thrown out. Another case involved a local police officer who got charged for catching the wrong size fish, basically poaching. Since he lied to the game officer in his statement, all prior convictions that relied on his testimony became easy appeal cases. Comment: when I knew a judge in Florida, this was a while back, he's long since retired, who insisted on seeing the calibration log for the radar device whenever cops brought a ticket to court. Apparently, he threw out a lot of tickets. Comment 2: semi-related, but in Pennsylvania, only state troopers are legally allowed to use radar guns, so city cops have to use either pacing or a system called VASCAR. VASCAR basically works like this. The officer sits somewhere they can see cars going down the road and passing over 2 points on the road that are a known distance apart, for example, 2 white lines painted on the asphalt that they know are 400 feet apart. The officer starts a stopwatch when the car passes the first line and stops it when it passes the second line. The officer enters the total elapsed time into a computer, and the computer calculates the speed. Since the whole thing is based on when the officer starts and stops the timer, you can see how big of a margin for error there is. Even a quarter of a second earlier laid on the button could skew the result from legal to speeding. Well, the state legislature thought so too. So in the law that authorizes city cops to use VASCAR, they included a provision that VASCAR cannot be used as evidence of a speeding offense unless at least one of 2 conditions is met. 1. The measured speed is 10 miles per hour or more greater than the posted speed limit. Or 2. The posted speed limit is 55 miles per hour or greater. So, in other words, if the speed limit is under 55, and they catch you going, say, 9 miles per hour over and give you a speeding ticket, their VASCAR reading is legally not admissible as evidence of that speeding offense. If they wrote that you were going 10 over or more, nothing you can do. But if they wrote that you were going 9 or less over the limit, and the limit is less than 55, you can go to court and get the ticket thrown out because that VASCAR reading is probably going to be the only evidence they have, and it won't be admissible. So the end result is, they have no evidence at all. I've gotten 3 separate tickets thrown out this way over the years. And in all 3 instances, neither the officer nor the judge had any idea that the law included that provision. Story 10 is: people have said, loopholes are rare. But this story jumps to mind. Wouldn't take much embellishment to make a dramatic TV moment. A convicted criminal was on furlough, a program with the jail where you can be released on an ankle monitor while still serving your sentence. He cut the monitor, ran, and was caught. He was indicted for escape. The case gets to trial, and the prosecutor puts on a pretty straightforward case. People from the jail, the ankle monitor company, and arresting officers testify. Then the defense moves to dismiss. The prosecution had failed to prove escape. There was actually a different law called unlawful evasion that applied to escaping from a furlough program. This was extra confusing because escape is the correct charge for cutting an ankle monitor if you are serving your sentence on an ankle monitor, which you can do sometimes. But if you start in jail and get out on an ankle monitor as part of a furlough program, then the crime is unlawful evasion. The prosecutor was furious because the defense could have dismissed the case at any point, from arraignment up to trial. But he never said anything. So the guy sat in jail for months awaiting trial on a charge he could get dismissed. The judge ordered the case dismissed. There was some small debate about whether he could be retried or not, because did double jeopardy attach if he was never actually charged with the right crime? But the district attorney wasn't going to highlight the embarrassment and just let it go. A crime, and slam dunk case, with a 6+ year sentence dismissed for a few months in jail. Comment 1: why did the defense wait and have his client sit in jail? Was he making sure the embarrassment to the prosecutor was the maximum possible? Narrator: I should have made that clear. If the case was dismissed before trial, the prosecutor could have easily fixed the mistake by re-indicting the case. When trial starts, double jeopardy attaches and he can't be tried again. That was the tactical reason by the defense and why the prosecutor was upset. He tried to argue to the judge that if the defense wanted to raise the issue, they had to raise it as a motion to dismiss indictment, which could be fixed, and not a motion for judgment of acquittal, which could not be fixed. Comment 2. I once escaped from a police car, and the prosecutor tried to go after me for something like a Class C or D felony and was furious when my lawyer's argument was, no, that was a Class B misdemeanor. He totally did that. It's on the police car dashcam. It films things well, but it's a Class B misdemeanor. He's still furious today. Story 11. Not me, but a professor I had who specialized in advocacy for victims of human trafficking. Basically, helping victims of trafficking avoid deportation. A salon was raided in connection to a suspected human trafficking ring. The tip turned out to be accurate. Multiple people were arrested, and several victims were taken into custody. Among them was a 4-year-old boy. None of the victims knew him. He helped clean the salon. The traffickers wouldn't admit where he came from. The child didn't know his own name, where he was from, or where his parents were. When the judge asked the child for his name, he replied, Spider-Man. When asked for his real name, he said, Peter Parker. You get the idea. Anyway, the prosecution wanted him deported because he was in the United States illegally. Not sure where the prosecution thought he'd be sent, but whatever. Now here's a neat thing. There's a federal statute on refugee eligibility. This particular statute hadn't been cited in over 60 years, but it was still valid law. It basically says that if a victim of human trafficking is an unaccompanied minor under a certain age and does not know their country of origin, they are to be granted asylum immediately, no court discretion. My professor intended to cite this statute. The prosecutor was terrified of creating new case law and offered to drop the charges if this statute wouldn't be brought up. My professor agreed because it was in the client's best interest. In a strange twist of fate, the prosecutor passed away, and the newly assigned prosecutor said he would not honor any pre-existing deals. My professor was like, fine, let's make some case law. The new prosecutor panicked and asked to return to the original deal, which was accepted. I suppose it's not a loophole, but very interesting in my opinion. Story 12 from Legal Eagle. Not a loophole but more a case of grievous malpractice. Some lawyers tried to use an artificial intelligence language model to write their brief. The language model fabricated and invented court cases and references. They filed it anyway. The opposing party candidly asked the judge, we don't seem to be able to find the mentioned cases in any of the legal databases. Could they please provide sources? The judge frowned. The lawyers panicked, tried to play dumb, and asked for more time while they used the same artificial intelligence tool again to write the fake cases. The judge was not amused. They got fined and humiliated, but surprisingly, not disbarred. Story 13. Not a lawyer, just a bibliophile and a fan of American history. In a book about Coke County, Texas, by a woman named Yarborough, she mentioned that a young man was taken before the judge in the small town for firing his gun in the street. The young man was brought before the judge, who pulled up the statute and read it. It essentially said, it is an offense to discharge a firearm in the streets of Robert Lee, Texas. The judge then asked the young man to describe exactly what he was doing, why, and where he was. The young man said, well, I was standing in the lot on this side of the street and saw a badger in the lot on the other side of the street. I pulled out my rifle and shot the badger. The judge said he was free to go, as he had not been standing in the street when he fired, and thus had not broken the law. Story 14. A friend was pulled over for expired plates while driving his mom's car and got a ticket. He went to court and tried to argue his case but was told he could plead guilty or innocent, with no deal on a lesser charge offered. So he pled innocent and went to trial. Side note, this guy is brilliant. Studied physics in college, worked with reactors for a few years, then gave up his high-income job to go to law school. In court during the short trial, he argued his ticket for expired plates was a tax violation, not a moving violation, and no one can be held liable for another person not paying their taxes. Somehow, the judge agreed. The judge tossed the ticket and thereby forced the district attorney to cancel the tickets of several other people who received similar violations. I was told lawmakers were forced to rewrite the law 6 months later. Story 15. I am a lawyer. I specialize in tax and litigation, civil, not criminal tax. The biggest loophole is money. Can you pay your lawyer to be as creative and annoying as possible? It's literally that simple. A very good example of this is former President Trump. Bog down the court with motion practice, beg for continuances, and throw absolutely everything possible, because you can. You won't see a public defender or low-income clinic attorney do this. There are simply not enough of them. Story 16. Not a lawyer. This happened about 10 years ago in Wayne, Pennsylvania. I was in court testifying against a former employee for stealing. The case before his was a drunk driving case. It was an open and shut case. A lady had blown twice the legal limit after driving into a parked car at a gas station. The prosecution's case was simply the arresting officer's testimony and the breathalyzer results. After the prosecutor questioned the officer and rested his case, you could see the defense lawyer chuckle. I thought it was odd, and then I found out why. The defense lawyer stood up and spouted off some Pennsylvania code and asked the judge for an immediate dismissal. The judge granted it but was visibly upset. He then immediately took a recess and called both the officer and the prosecutor into his chambers. It was about 3 minutes of the judge yelling at them, and the whole courtroom could hear it. It turned out that at some point during the prosecution's case, either the prosecutor was supposed to ask the officer or the officer was supposed to state that he had been specifically trained to use the breathalyzer and detect impaired driving. By failing to do so, the prosecution failed to meet the necessary requirements for a conviction. It was wild. Story 17. Criminal defendants charged with stealing an item must be charged with stealing an item from someone. That someone must be a legal entity. I once represented a man who was charged with stealing dog food. He was homeless and trying to feed his dog. Needless to say, I was sympathetic, so I was willing to pull something of a tricky move for him. I queued him up for trial. As soon as the first witness was sworn in, I moved to dismiss. The entity he was charged with stealing from? Wal Mart. That is not a legal entity. I think the real name was Wal Mart Stores, Inc. or something similar. Case immediately dismissed. Since a witness had been sworn in, double jeopardy prevented them from trying him again. Story 18. Wild loopholes aren't really a thing, but what I have seen a lot is judges knowing absolutely nothing about a particular area and being convinced to make a blatantly wrong decision by a quack expert because they don't understand the expertise of the actual, real qualified expert and therefore cannot be appropriately convinced by it. To give a general example of where this type of thing comes up, quack experts have caused judges to send people to prison for serious crimes like homicide because they present bunk statistics that sound really convincing. That the chance of this person being innocent is like 0.000001%, and the judge, or jury, doesn't understand statistics, so they're convinced by that. Comment 1. In addition to quack experts' exaggerated numbers, there are also completely correct statistics presented by real experts that are intentionally misleading. The defense in the O.J. Simpson trial at one point argued that the chance a domestic abuser murders their spouse is really low, which is true. The problem is that it isn't the correct comparison. The correct comparison would be the chance that a domestic abuser, whose spouse ends up murdered, is the perpetrator of the murder. That turns out to be quite high. Story 19. Not a lawyer, but close to one. In law school in Finland, we were taught about a case where a man was on trial for failing to pay back a loan. His lawyer argued that he shouldn't be convicted of delinquency, no idea what the actual legal term would be in English, because he never intended to pay the loan back in the first place. And he won the case. The reason was because the prosecutor had made a mistake. They had prosecuted the man only for the lesser charge of being delinquent in making payments and forgot to write up the alternative charge of outright fraud. So the court had to rule that there was reasonable doubt whether the man had actually committed the specific act he was on trial for. Story 20. My dad is a lawyer, and he told me this story the other day. My older brother switched high schools right before his senior year to play football for a coach that my dad was really good friends with. Normally, you have to sit out a year if you transfer. But my dad knew of a rule in the state bylaws that said a judge's order declaring a student eligible makes them eligible to play immediately. So he went to his judge buddy's house and got him to amend the custody agreement, basically stating that my brother was immediately eligible. They ended up having to go in front of the board of directors and everything, but my dad basically showed them their own rule and won. My brother got to play. They removed the rule before the next season. Story 21. My grandpa was a lawyer for an oil company a few decades ago. They had a huge federal case one time, and he simply went up to the judges and told them they didn't have jurisdiction. The oil was drilled in Texas and refined in Texas, and it had never left the state of Texas. So there was no interstate commerce, and the federal court had no jurisdiction. He got the case thrown out, end bank. Story 22. There was one guy who owed $464 million in bond, and his lawyers said he couldn't pay it and didn't have the money to pay it. He then went on to say he did in fact have the money but didn't want to pay it, so they appealed, hoping to lower it. The day of the deadline, a court announced they'd be lowering the bond to $175 million. It was a crazy loophole. He escaped consequences. Story 23. I am not a lawyer, but in college, we would have bonfire parties in the woods. I was friends with two other guys, and we were all Eagle Scouts. They were stoners. I was not. The two stoners got caught smoking in their car in the school parking garage. A police officer searched the car and pulled out my machete from the previous week's bonfire. Stoned out of their minds and freaking out, they immediately told the cops it was mine, not theirs. Fair enough. I got a summons to the college disciplinary board for violating handbook rule XXYZ. Well, I looked up the rule, and it said no knives, firearms, or martial arts weapons in the dorms. They basically said, sign here and write a 5-page essay about why you follow the rules. I said no, I didn't violate the rule. It was never in the dorms. They replied that the parking garage counts as the dorms. I told them I didn't take it in the garage. My dorm was a mile away. I parked close to my dorm. They said the parking lot adjacent counts. I said I parked in the auxiliary lot since there's one space for every 3 residents adjacent to the building. They said that lot, 300 yards from the dorms, still counts as the dorms. So I replied that it wasn't a weapon. It was a tool. You buy it at the home improvement store, and the lawn crews on campus use them. They told me to sign, and I flat out refused. They gave up and said I could go. I asked, where's my tool? They initially said it had been destroyed. I said, you owe me a machete. Then it turned out the campus police had it. They were surprisingly more chill about it than the admin when I talked about scouts. Story 24. Anti-LGBT laws in Hungary missed a comma, which changed the whole meaning. The intent was that all books with a gay character should be wrapped in foil and sold separately from other books. The actual law stated that if the books are sold separately from other books, they should be wrapped. A bookstore was fined. They went to court and won. Their huge fine was dismissed. Story 25. Not a lawyer, but I once got a ticket for having my dog off leash at a park in Denver while the park rangers let another offender go with just a warning because they felt bad that the other dog only had 3 legs. I successfully argued that my rights had been violated under the Equal Protection Clause of the 14th Amendment, which requires law enforcement to provide a valid reason for treating similarly situated people differently. We both had dogs, both off leash, in the same park, at the same time, stopped by the same officers in a single interaction. The law does not exempt 3-legged dogs from being on a leash, so they were forced to throw my ticket out. Story 26. Not a lawyer, but I got pulled over driving a buddy's car at 3 a.m. on a back road I wasn't familiar with. The daytime running lights were on, so no brake lights, my mistake, and I drove right by someone else they had already pulled over. I knew I was in trouble when they pulled out after me. They said I was acting suspicious, demanded to search or else they'd call in a police dog, and found my cannabis and set it on the hood of the car. They filled out a little slip saying it was cannabis, etc. Well, the court date arrived, and my lawyer asked the first officer if he did a field test to confirm whether it really was cannabis or just hemp. He said he thought he did. They sent that one back and called out the other officer, asking him the same question. He answered that he wasn't sure and didn't remember if it was done or not. I also stated that I did not see a field test done to confirm that there was tetrahydrocannabinol present, and the judge scoffed at the officers and dropped it. Phew. Only spent a couple weeks in jail for the other charges. Story 27. I know someone who was arrested for trespassing in a bank during an Occupy Wall Street protest. Since the bank had received a huge public bailout and hadn't yet repaid its debt to the U.S. government, my friend's lawyer was able to argue that the bank was public property, and they got the case thrown out. Story 28. I went to court and watched my lawyer boldly lie. He asked me something before going in, I confirmed it, and then he stated the exact opposite to the judge's face. When we were leaving, a couple of other lawyers complimented him on his speech. Most of them lie, and everyone knows it. Whoever is the better liar often wins, and it is acceptable, which is a bit of a loophole if you ask me. Comment 1. I was a lawyer for about 25 years, and most of them do not lie. Yes, there are some who do lie, and most will shade what they say in the light most favorable to their client, but most do not flat out lie. Flat out lying to a judge is a good way to lose your license and career. Comment 2. My mother-in-law is a lawyer, and she was venting about a case she was brought onto where the prosecution spent 10 months fabricating evidence to sue the defendant for fraud that never happened. The highlight of this conversation was a very spirited, "I will eat your lunch. You don't get to lie." Story 29. Not a lawyer, but I know a tiny bit about taxes. It blows my mind how tax laws have seen everything people can think of to get around paying taxes and seem pretty airtight. There are a couple of strategies for avoiding estate taxes, though. Not necessarily loopholes, but definitely ways to avoid estate tax at the federal level if you know how. Story 30. Not a lawyer, and not really a loophole, but, to summarize. I, a young single male at the time, bought a mobile home and rented the lot it was placed on from an old landlord who made my life miserable. Due to dealing with the landlord and financial issues, I let the new mobile home get repossessed by the loan company and moved out. The landlord sued me for back rent and tried to tack on all sorts of extra charges for mowing the yard and similar things. I was improperly served at my workplace, but I went to court anyway. I didn't know anything about the law and couldn't afford a lawyer, but I had some ideas about how to defend myself. The landlord gave his complaints, and I could tell the rural old judge was ready to rule for the landlord. I asked the judge if I could speak and brought up the incorrect service, mentioning that I believed this violated my rights. The judge seemed annoyed, sighed, and told the landlord, "You have a problem." He then offered a choice. They could drop the case and try to properly re-serve me and file another case, or he would discount the judgment today after considering my complaint about the service. He asked if I agreed. I asked to speak again, and the judge allowed it. I asked when the last time I was paid up on rent was. The landlord gave the date. I asked the same about mowing the yard and other issues, and he agreed on the same date. I then told the judge that as of that date, I had relinquished the mobile home to the loan company in a repossession and handed over the paper from the loan company stating that it was being repossessed on that date. I then argued that any issues or charges from that date forward should be on the loan company as the owner, not me. The judge sighed even harder and ruled in my favor, giving the landlord a zero judgment, but did state that I needed to provide the landlord with the loan company's contact info so he could try to collect against them. As soon as the case was dismissed and we walked outside the courtroom, I walked over to that landlord, handed him the loan company letter, said, "Good luck, buddy," and walked out of the building. Story 31. I've seen a homicide conviction overturned due to a speedy trial violation. Not really a loophole. More of a fundamental right guaranteed by the Constitution. But to the average person, it sure looks like a technicality. The thing is, a speedy trial is constitutionally protected, but the law doesn't put a specific number on it. It's more about what's reasonable. However, most states have their own speedy trial protections in their state constitutions, and many also codify this right in statutes. These statutes often have specific numbers, like requiring that someone must be brought to trial within 90 days, for example. Courts and lawmakers aren't eager to let people go for these sorts of things, so there are tons of rules and exceptions. Like continuances requested by the defense not counting against the time, or crowded docket exceptions, and so on. But sometimes, no matter how much you stretch it, the math just doesn't add up. In the particular case I'm thinking of, neither the prosecutor nor the court was tracking the time correctly. When the deadline expired, the defense moved for dismissal. The court didn't want to dismiss it, so they went ahead with the trial anyway, but it was overturned on appeal. This could have easily been avoided if the court had simply made some findings on the record about scheduling conflicts, but they didn't. They even tried to retroactively fix it, but the appellate court said, "The law here is clear, and you didn't follow it, so we're bound by it." Usually, I'm very pro-defense, but this particular defendant was a terrible person. It was an unfortunate case all around. Moral of the story: pay attention to who you're voting for as district attorney.